As the day's session came to a close at the Greenwood County Magistrate Court in Eureka, Kansas, courtroom cameras recorded a seemingly private moment between Judge Phyllis Webster and County Attorney Jill Gillette. The two were talking about several defendants who had failed to show up for their scheduled hearings. During their exchange, Judge Phyllis realized that a procedural error had left her unable to impose any formal penalties on those who were absent. She further hinted that the mistake might have originated from the county attorney's office. Gillette's response to this suggestion quickly escalated the conversation into a tense confrontation, one that could jeopardize her entire legal career.
Tanya Sanchez.
We already did Sanchez. We have a Tiana Richardson and a Dustin Newport I still have.
Well, hold on. That's not what I'm showing. What do you have, Missy?
I have Alfonso Caldwell and Tiana Richardson. That Newport bonded out, or no, well, he bonded on ours and then Lyon County come and got him before.
I noticed, okay, he was taken off the docket. And what did I do? Mix up Tanya Richardson and Sanchez?
Mm-hmm.
And no one mentioned that I was using the wrong name?
You were using the right name.
Well, and these are my couple that I don't have anything filed to show that they have to be in court. I don't have a summons. I don't have a uniform notice to appear issued by the officer in the ticket.
Judge, the girls filed the ticket earlier today.
Okay, let me see if it's, maybe I just need to double check. Mr. Caldwell.
Mm-hmm. Tickets were issued January 23rd, 25 at 20:59 hours. But
Okay,
today,
well, let me make sure they made it to the file because I'm not seeing that. I don't see that, Ms. Gillette, and until I have filed verification that they had noticed this hearing. I'm not finding that. You're sure they filed them?
Arlene was the one who did it for us.
No, Missy, do you have that where you can look at it? Because I am not seeing it filed. Maybe I need to. No, I think I've already refreshed to see if they've been added. What was that, Missy?
I said they're not showing up in the case yet.
I don't know if upstairs hasn't approved them or what's going on.
I can check.
Would you check? We'll take just a real quick recess because I don't have anything in the file to show they have notice of the hearing, so I can't take any action for their failure to appear without it.
Judge Webster maintains that she cannot take legal action against the defendants who missed their scheduled court hearings unless there is verified documentation showing they were properly notified of their appearance dates. Typically, when someone intentionally skips a mandatory court session, a judge has the power to issue a bench warrant, a legal directive authorizing law enforcement to locate and arrest the individual. For example, Section 1947-39 of the Kansas statutes empowers judges to hold in contempt and issue bench warrants for anyone charged with violating county codes who fails to appear in court. However, that same law clearly states such authority applies only when the person has been officially notified and still fails to attend. While the exact charges against the absentee defendants remain unclear, proof of proper notification is crucial in showing that their absence was deliberate. Thus, Judge Webster's decision to refrain from moving forward without concrete evidence that each defendant was duly informed seems entirely justified.
Arlene's going to bring the unfiled copy upstairs, Your Honor, but they were submitted this morning by Jessica.
I need the originals. You're thinking the originals are on file somewhere or waiting to be filed? See what Missy finds. Maybe they'll find the originals at the clerk's.
What, Judge? I'm sorry, I'm back now.
Well, she said they'll bring up, if I understood Miss Gillette right, they're bringing up copies, but where are the originals?
I think I actually have a copy because I was asking them today about it, so
Well, I
I
need,
can print you off the copies that I got
no,
sent.
copies, I need original documentation that these people had notice of this hearing, either in the form of a returned summons or a citation. And I don't have one of anything to show that they know about this hearing today.
Your Honor, the citations, we get a Xerox of them. We don't get the originals. The originals normally stay either in the file with the sheriff's office now, or they go straight upstairs. But this had to be long formed because it's marijuana. And so
Well, even with the long form, I would accept, you don't have the originals, Arlene? What do you have? You have copies? Have those been filed with the clerk?
Yes.
They have been filed. They didn't make it into their file. Do you know why?
Well, because that's the clerks.
Well, Missy, did you check with the clerks?
Yes, I just checked with them and they have not been, they do not have them. They're not in the queue to approve.
I know they're not in the queue. I looked through the queue. Oh, unless you mean their queue.
Yeah,
Well,
they're,
what I'm going to do, now I'm looking at copies of tickets. And I've seen enough tickets over the years to know these are tickets, and they do appear to be signed by the signature I know as Blake Fisher's, although I'm not an expert in handwriting. But I am not comfortable issuing any kind of failure to appear warrants if there's no documentation in the file. These are just handed to me, but once they are filed, then I would not hesitate to issue warrants for their failures to appear. So I'm going to set these two cases over till next Tuesday. By then, I'm sure that we'll figure out why those haven't been filed. And then if they're not here at that date and time, we'll issue warrants. But they'll have to be given notice of the new date and time. And it looks like they're out of Wichita, Kansas. Yes, so.
if I have to issue new summonses, then it's going to be more than a week because I have to issue them, send them to Wichita, and have them served on them. They have their notices to appear, complaints.
All right, I'll tell you what, I don't.
I don't even get the original anymore.
Just file the copies, whatever, but they have to be filed, Miss Gillette. I have nothing that gives me legal authority to issue failure to appear warrants. I have in the file, and I'm looking at it, a complaint, a probable cause affidavit, a notice that you're going to rely on KBI reports, and that's it. There is nothing in the file to show legally that they have notice of this hearing. So I don't know where the tickets are. I don't know why they're not filed. I understand that someone in your office said they gave them to the clerk. I understand the clerk to say they don't have them. I don't know where they are, but I do not have them, so I cannot issue any kind of warrant for failure to appear. In fact, if you find them and get them in there even today, we can deal with it today rather than trying to issue summonses. Get me something I can legally use. Otherwise,
I'll call Sheriff Samuels and ask him if he can bring the originals out of his file.
I'm not telling you have to do the originals. I'm just telling you, Miss Gillette, I cannot legally issue a warrant, and you know that. You know I have to have verification before I issue a warrant.
And we emailed them to your staff who has them this morning. They were sent to
My secretary is not the clerk of the district court. My secretary is not the custodian for that. They have to be filed.
Up to you. I'm not going to argue with you.
Well, you better not.
We'll just take it up later.
Miss Gillette, who is the judge here? I am not going to accept your behavior. You're putting me in a position where I'm going to have to find you in contempt of court if you're going to act like this.
I don't have the original, Judge. I can't get it to you. We filed them this morning. That's all I can tell you.
Miss Gillette, you are not listening to me, and you're being contemptuous.
The state has contempt immunity. We already briefed this. If you would like us to get them filed again, we will file.
You have contempt immunity? Do you have ethical immunity that you can talk to a judge any way you want and have no repercussions? Is this what you're saying?
Ms. Gillette argues that prosecutors are essentially immune from being held in contempt of court. Judge Webster, however, firmly counters that every attorney, including prosecutors, remains accountable to professional ethics and legal standards while practicing. The 1976 Supreme Court decision in Imbler v. Pachtman clarified this principle, ruling that state prosecutors are granted full immunity from civil lawsuits for actions taken within the scope of their official duties, such as initiating or pursuing criminal cases. The court acknowledged that this protection might sometimes prevent defendants from suing even dishonest or malicious prosecutors, but emphasized that removing such immunity would do greater damage to the justice system. Without it, prosecutors could become hesitant, overly cautious, or reluctant to act decisively, ultimately undermining their ability to enforce the law fairly and effectively. However, that legal immunity applies solely to civil lawsuits brought by defendants. It does not protect prosecutors from disciplinary measures within the courtroom, such as being held in contempt. According to Kansas law, Section 20-1203 grants judges the authority to punish individuals for direct contempt, as defined in Section 20-1202. This includes any act of disrespect, disruption, or improper conduct committed in the judge's immediate presence during court proceedings. The statute makes no exception for prosecutors. In fact, courts have repeatedly affirmed that judges possess the right to hold attorneys in contempt whenever their behavior crosses professional boundaries. A notable example comes from the 1877 case in re Pryor, where the Kansas Supreme Court ruled that an attorney could indeed be punished for contempt if they used offensive or disrespectful language in court. The justices emphasized that lawyers occupy a position of privilege and trust within the legal system, and as such, they are expected to demonstrate restraint, respect, and professionalism at all times before the bench. While attorneys have every right to question, debate, or even criticize matters argued in court, that freedom must always be exercised with civility and a commitment to preserving the court's dignity and the integrity of the legal profession. Courtroom discourtesy or disrespect isn't merely bad manners. It violates an attorney's professional and ethical duties. In more serious cases, such behavior can amount to a grave breach of those duties, giving a judge legitimate grounds to impose contempt as a disciplinary sanction. In my review of the law, I found no precedent supporting Ms. Gillette's claim that prosecutors are immune from contempt. She did, however, say she had briefed the matter, which suggests she may have prepared a legal memo or located authorities she believes back her position. It would be revealing to see that brief to understand the legal reasoning or sources she relied upon. Even if, for the sake of argument, prosecutors in Kansas were somehow considered immune from contempt proceedings, Judge Webster was entirely correct in emphasizing that all attorneys remain bound by the ethical rules governing their conduct in court. Every lawyer is responsible for their behavior and may face professional discipline if they fail to uphold those ethical standards. In particular, Rule 3.5-D of the Kansas Rules of Professional Conduct clearly states that a lawyer shall not engage in undignified or discourteous conduct that degrades a tribunal. In simple terms, regardless of how tense or emotional a situation may become, attorneys are expected to treat the court with respect and maintain proper decorum at all times. Therefore, Ms. Gillette's tone and demeanor toward Judge Webster could justifiably subject her to ethical scrutiny or even formal disciplinary action for violating the same professional standards of civility and respect that apply to every member of the legal profession.
Judge, I will find the originals, whoever has them, and we'll see if we can get them to you. We will get them filed.
And we will finish this later, Miss Gillette. At this time, Missy, it looks like Miss Gillette has decided to remove herself from the hearing. As I said, this matter is not over and it will not be tolerated. But for now, we will be in recess.
It remains uncertain whether Ms. Gillette faced any disciplinary repercussions following the incident. Nevertheless, she has continued to appear in court and seems to have maintained a professional and respectful working relationship with Judge Webster. The episode serves as a powerful reminder that while prosecutors are granted a certain level of legal immunity when carrying out their official responsibilities, that protection does not place them above accountability. When they act in bad faith or disregard established courtroom protocols, they can still be held answerable for their conduct. Like all other members of the justice system, prosecutors are required to follow the same procedural and administrative rules that ensure fairness, transparency, and integrity. Judge Webster, for her part, deserves acknowledgement for her steadfast adherence to the rule of law. She declined to offer as arrest warrants for defendants when she believed she lacked the proper legal authority to do so. Although her decision was likely influenced by the information provided by Ms. Gillette, she firmly insisted that the prosecution complete its administrative responsibilities before any warrants could be issued. In doing so, Judge Webster reaffirmed a fundamental judicial principle: that government officials should never be granted privileges or exemptions unavailable to ordinary citizens. Her decision ultimately strengthens public trust and confidence in the fairness and integrity of the judicial system. It's important to remember that this isolated incident should not be viewed as a complete reflection of Ms. Gillette's overall professionalism or competence. Nothing in this situation suggests that she is unqualified, incapable, or unfit to continue serving as a county attorney. Procedural mistakes and emotional moments are not uncommon, particularly in demanding professions like law, where the stakes are high and pressure runs deep. While her reaction in that instance may not have been ideal, it simply underscores the reality of human imperfection, something everyone encounters when stress and responsibility collide. We've all had difficult days at work, and this event serves as a relatable reminder of that shared human experience. If you'd like us to cover more real-life courtroom moments or analyze other significant legal stories, share your thoughts in the comments below. And as always, thank you for watching. Don't forget to like, share, and subscribe to support our mission of building a more informed, thoughtful, and justice-aware community.